Hello, everyone, and a good afternoon to you all. Can you believe it? It's just been, I think, over 2 months since we last spoke. I think even President Cyril Ramaphosa had a few family meetings with you over the past 2 months, but we didn't. I do hope that everyone had some well-deserved rest and that you and your families are healthy and ready for 2021. We covered some incredible topics during our webinars that happened during 2020. And if you missed any of these, you can definitely still access them via different platforms, which includes our EasyMedDoc Solutions website. There's a YouTube channel, there's different podcasts as well. What I'm going to do to try and assist you there, I'm just quickly going to copy the links and I'm going to paste that for you in the chat functionality so that should you wish to, you can copy and paste it from there and use it at a later stage. There you go, you should have that now. Today we're here for your benefit. We're going to have another very informative chat, and we really don't want any of you to leave here today without your questions being answered around medical professional indemnity. So please make use of the chat or the Q&A functionality to pose your questions, and I'm going to ask the panelists to keep a very close eye on those. Before I introduce our panel, however, today, let me just quickly highlight who is virtually joining us on this webinar. We've got 500 and going on 550 people that registered, of which there are 19 different disciplines. Let me share some of the numbers with you. There's over 150 psychologists, just over 70 physiotherapists. There are 64 occupational therapists, around 20 bios. There's 45 for speech therapists and audiologists. We've got just over 10 dietitians, over 30 registered counselors, around 20 podiatrists and medical orthotists and prosthetists, a handful of social workers, 50 chiropractors, that's quite a few, also quite a few optometrists and even a few doctors. So a warm welcome to everyone, and it is really great having you all back again. Our panelists today, they should all be familiar to you, but just in case there are some new attendees, I'm going to introduce, first of all, let's start with Dr. Brad Byra. He's a qualified chiropractor. He's also the founder and the managing director of the advisory group. And seeing, Brad, that you do have a BCom law degree, you're very well positioned to be a medico-legal expert, if I'm not mistaken.
Thanks, Lani. That sets the bar high.
I think the last time you sort of graced us with your presence was on the 5th of November. So thank you very much for joining us again today. I think following the 5th of November's webinar, it was on the 12th of November where both Michael John DeMont and Richard Lynn joined us as well for a good discussion. Michael John DeMont being the director of Genoa Underwriter Managers, and then Richard Lynn, the managing director of Shackleton Risk Management. Gentlemen, thank you very much for joining us today and making yourselves available to answer our audience's questions around MPI. And I think it's always really good. Oh, fantastic, thank you. It's always really good to put a face to a name and to the company that you all represent. As you know, my name is Lani Ace and I'm a product manager with the SpaceNet Global Group, and it's my pleasure again to host this afternoon's webinar. Just for those of you who have joined a little bit late, as I was saying earlier, this afternoon's about you and the questions that you may have around medical professional indemnity. Please ask your questions by using either the chat or the Q&A functionality, and the panel will try and answer as many of these as possible. However, I do think as a start, we need to start with the who's who, and perhaps just share a little bit more information around the identity of all the companies involved. Perhaps we can start with Genoa. Who is Genoa and what is the level of experience in the organization? Michael John, are you best positioned to answer this?
Absolutely, Lani, and thank you for the opportunity to address all of the attendees this afternoon. I'd just like to reiterate what Lani said a little bit earlier, is that the core intention of today's seminar is for us to answer any concerns, for you to get to know us in terms of who we are and what we represent. But as Lani indicated, I'm one of the directors of Genoa Underwriting Managers. We are a liability specialists. So what that means is we focus on professional indemnity for different specialities, one of those being medical practitioners like yourselves. Genoa has got a very, very experienced team of multiple underwriters across multiple disciplines, as well as 24/7 medico-legal advice and attorneys who are on call 24/7, as I said, in the event that anyone is faced with a claim. Genoa as itself is a division of a larger insurance company called Sapphire Insurance Company. And then over and above that, we are the first company in South Africa to be reinsured by Munich Re, the largest reinsurance company in the world, for a medical malpractice product. Why that's important for you and why I'm raising it is, in order for a company to get a very well-established reinsurer like Munich Re on board, and also to be the first in South Africa, I think speaks to our track record in the medical malpractice space and our ability to look after you, the insureds and the practitioners. Lani, does that answer it? Would you like me to go into a little bit more detail? Or are you happy?
No, I think that's a brilliant start. Thank you very much, Michael. And I think you answered my next question as well, as where does Sapphire fit into all of this? Because that's another name that we keep on hearing. But perhaps, Richard, let's turn to you and you can explain to our audience a little bit more about Shackleton and perhaps what credentials they hold.
Sure. Hi, everyone. So to just give you some context, Shackleton Risk is a countrywide insurance brokerage firm. So I suppose in the flow of insurance, the people that you deal with regarding your insurance policy and the company that's responsible for giving you advice surrounding it is the brokerage firm. So that's my firm. As I said, we are a countrywide firm. We employ over 75 people with dozens of qualified reps who can answer queries. Our areas of expertise range from surety bonds, which are surety products issued for liquidations and executorships and so forth. And we also specialize in liability insurance, so professional indemnity across various professions such as attorneys, fiduciary practitioners, business rescue practitioners, medical practitioners, architects, engineers, and so forth. So we definitely like to stick to our strength, and we sort of play in the market of professional people, and we don't steer out of that. We also don't do any type of insurance that is not liability insurance. We focus purely on liability insurance and try to master our craft, so to speak. Shackleton Risk is part of a greater group of companies. There's two other major entities involved. One is called Shackleton Credit, which is a company that buys non-performing loans from banks, from commercial banks, and collects it. That business employs about 240 people. And we also have a life insurance company called Shackleton Life, where we work with Old Mutual, which is a direct to market life insurance company. Just some background about myself. I'm a chartered accountant. I did my accounting articles at EY in Joburg. I'm also a chartered financial analyst and obviously a qualified rep in terms of insurance and so forth. So yeah, I hope that kind of explains and positions the firm. And I think it's just, I suppose, at a basic level, important to just know broker, person you speak to, underwriters, sort out the insurance basically. So I suppose that's a simplistic view of it.
I think that's a really good summary. Thank you, Richard. Now, Brad, as an independent medico-legal advisor, where do you fit into all of this?
So, Lani, that's a hard question and an easy one at the same time. So I tell people I'm new to, bless you, I'm new to private practice. I started in 1996. And from practice, I then worked as head of health risk for two large global insurance groups, one called Aon and then one called Marsh. And in doing that, I worked in medical, I don't like to call it medical malpractice because it annoys me. It's the only profession where it's labeled malpractice. So professional indemnity insurance for our professions, healthcare professionals. I've been involved in writing, designing, and doing everywhere from east of New York and west of San Francisco since 2004. So it's been a long journey for me. So when I came back into the country, went back into practice, I then met with MJ and the Genoa team, and we started saying, well, how can we work differently, and how can we provide practice-specific, healthcare-specific insurance where it's needed. And then through partnerships with yourselves and with Genoa, sharing these messages, the question always comes out, well, what's the best product and who's the best broker? So my job has been to introduce different products and different brokers to different parties so that they can choose, and then switch the lights on and say, the language of healthcare is very, very different from the language of insurance. So 90% of my day is spent saying, well, what is cover? What is cover? What's a mutual cover versus a policy? What is claims made versus occurrence? What do I need? What are my limits? And happily, I'm not going to talk about any of that today, but my role as an independent advisor is to give people perspective. And so what I'm here to do today is, if you want to know a question about the industry at large, I'm here to answer it.
Brilliant. Thank you. Thank you very much for that summary, Brad. I really appreciate that. Now, as Profnet, as you might know, we did a thorough review of medical insurance providers. Brad provided us with a lot of independent information as well. And Profnet did decide at the end of last year that we are going to partner then with Shackleton Risk Management, together with Sapphire and with Genoa. And Profnet is a very well-known name under the healthcare providers, and we do still from time to time receive some questions. And there's some questions that repeat. And we thought it wise today to perhaps start tackling those. And I'm still waiting for our attendees to post some questions. We are keeping an eye on that, so please use the chat or the Q&A functionality, and we'll definitely get to those questions. But let's perhaps start with one of the questions that repeats the most, and that is, what is retroactive cover? Guys, I'm not sure who's going to take this one.
MJ, should we just go 1-1?
Yeah,
I don't mind
absolutely.
starting.
Yeah,
Okay.
Go ahead.
I'll kick off. So retroactive cover is an important concept to understand. And it's particularly important when you are moving between insurance policies. So basically, in a nutshell, it is the date that you need to be aware of when moving insurance policies that your new insurance company needs to understand and be told. So picture a scenario where you have insurance, let's say, from the 1st of January 2018 for a year, and on the 1st of January 2019, you switch insurance companies. You need to tell, and your broker will ask you this. It is the broker's job to ask you this, so you don't need to remember to tell, but just in terms of completeness sake, we will ask you, when did you first take out insurance? Please send me your current insurance policy. You will show us that. That will show the date that you first took out insurance, and it is our job to communicate that date to the underwriters so that they can cover you for all work performed from that original date. In my example, it was from the 1st of January 2018, even though you're taking out insurance with your new insurance provider on the 1st of January 2019. That way you ensure that that year of work, when you were insured by a previous company, is still covered by your new insurance company, even though they weren't the insurer during that period of time. It's called making sure there's no gaps in cover, and it is something that your broker, in this instance, Shackleton Risk Management, will look after. But in terms of filling you in about what that means, that's basically the concept.
Perfect. Thank you, Richard. I'm seeing there's a question that came in from Anzaret. Which of these companies offer insurance that can be paid monthly and not a once-off payment?
MJ, do you know first?
Yeah, absolutely. Anzaret van Rooyen, I'm happy to take that. You are currently speaking to the insurance company that offers you both the option to pay monthly or annually. I don't believe that that option is available under other providers in the market under their scheme options. So yes, we're proud to advise that because we know what a financial strain some of the premiums can be being paid off in a once-off hit, we do allow you to pay that premium over 12 months.
Fantastic. I hope that answered your question. Thanks. And can you belong to two brokers at the same time?
So, Rich, you happy if I take this?
Sure, go for it.
Solomon, so the short answer is yes, you can. But why would you want to? Is the second question. Sometimes there are brokers that are specifically specialist within certain areas. So, for example, Shackleton Risk, as Richard mentioned earlier, is a liability-focused insurer. So any professional indemnity, medical liability that attaches, I almost said medical malpractice, Brad, and then I heard that you don't like the word malpractice. Any of those insurances would traditionally be with a specialist broker like Shackleton Risk Management. However, in the event that you have, for example, your home and your house, often there are short-term brokers that specialize in those industries. So it's all about, if I gave you an example, when you have your car serviced every 6 months to a year, you would generally take it to an approved dealer who you know is going to look after your vehicle. It's the same kind of thing with your insurances, where my recommendation would always be that you place the insurances with the specialist in that space. The short answer is yes, you can have more than one broker, but it's traditionally recommended to keep the insurances with the brokerages that are specific and experts in those spaces.
Mm-hmm. Okay.
I see Amanda's question. Lani, should I go first?
Please do.
Okay, so sorry, I'm just checking who answered. Oh, sorry, who answered the question? It's disappeared.
The question was, can you
by
offer what?
Amanda. So Amanda, just to answer your question about offering what MPS offers. So I think I'll start by answering that by talking about what MPS is in terms of their offering and what company they are versus what the offering that we have is. MPS is a mutual fund. They're a non-South African firm. They're actually a British firm. They don't have what's called a policy wording. A policy wording is basically the terms and conditions of your insurance. So they don't specify the limit you have. They don't specify when you are covered, when you aren't covered. It's actually discretionary on their behalf, and they just kind of pick and choose what they'd like to do. That's what's called a mutual fund. It's not actually a true mutual fund, because a mutual fund is supposed to pay out the profits that they make to its members, which MPS does not do. They keep all the profits themselves. So I would say that calling themselves a mutual fund is perhaps misleading, but be that as it may. The only material difference between the policy that MPS offers and the policy that we offer is the policy that MPS offers gives you an extended runoff period that you pay for included in your premium. The policy that Genoa offers is one where you are covered for your career. You then automatically get, I think in this particular property policy, it's 6 years runoff. MJ can correct me if I'm wrong. Automatically included in your policy. Should you wish to extend your runoff beyond that 6-year period, you can do so at your choosing, and you will pay an additional premium for that, bearing in mind that what you would pay Genoa each year compared to MPS is significantly lower. So if you wanted to extend your runoff cover for 21 years, which is the theoretical longest period you could be liable for if you had done something to a newborn baby right before you retired or something like that, and they only sued you at 21 and all those sorts of unlikely complexities, then you can do so, and you can match the policy in terms of runoff, and you can still save more. But ultimately, it is not recommended for everyone to extend your runoff for an extended period of time, because everyone's practice is different and everyone's circumstance is different. So, the policy allows you to choose how much runoff you want and so forth. So to answer it in short, yes, we can offer something very similar, but it's all up to you. I think choice is always preferable.
Thanks, Richard. Thank you. Brad, can I ask
Lani?
you to, yeah, go for it. I think you know what I'm going to ask.
I think you're going to ask if I can answer. Do I pronounce this person's name Masurami?
Please do.
The question is around psycholegal assessments and defendant lawyers. And look, that's a hard one to answer, because the contract that you enter into with a defendant lawyer should agree to what your payment terms are if you're doing an assessment. So I know when I do a medical legal report, whether it's a joint minute or it's for the defendant or it's for either party, I say to them, here is my terms, here's my fee, and my expectation is that I'm paid 50% to start before I see the patient and 50% on the delivery of my report, because it's the attorney's obligation to pay you. That's part A. Part B is if you've given a concession to them where you're saying they're working on contingency and you're working on risk, you can have 72 months from the time that the matter is assessed till when it's heard, till when it's settled. The average case, according to the South African Law Reform Commission, is settled in 7 years. So you've got to bear in mind that it can take an inordinate amount of time. So most people that I know that do these kind of assessments, and I'm the corporate advisor to the Medical Legal Association on a variety of issues. And when I speak to some of the colleagues, what we find is they've got outstanding bills for between 48 and 72 months. So we can talk about this offline because it's not really strictly about today, but it is how you contract with these other parties to get paid.
Perfect, thank you. Thanks for addressing that. There's been a few questions on how can we contact, who do we contact if we've got insurance or broker related questions. I did share that email addresses with you. If you've got any broker or insurer related questions, please email medmal@srisk.co.za. Or if you've got any Profnet membership related questions, it is info@profnetmedical.co.za. I made a spelling mistake there. Let me see if I can quickly correct that. No, I will put it in again. Oh, Richard, do me a favor and just type that email address for me, please.
So if you look down in the chat, Lani, I did send a message where
Oh, thank you.
So
apparently I can't spell the word risk.
With a K.
After the S. So, guys, another question that keeps coming up, and I had to get my head around this abbreviation ERP as well, extended reporting period or an additional reported period. This gets used very often. We get a few questions around that. Please explain to us what this is about, what the abbreviation stands for, what it means.
Okay, great. Lani, that's a very, very good question. And also, like Richard said, the retroactive date is important. Equally important is, in fact, the extended reporting period date. Some other policies in the market, they refer to this as an additional reporting period. We refer to it as an extended reporting period, but they're the same thing. Why that date is so important and is because Richard mentioned that the policy is a claims-made based policy. What that means by its nature is that the policy has to be in place at the time the claim is lodged against you, the practitioner. If the policy was cancelled for some reason or moved or not in place and you didn't have this extended reporting period, then the insurance company could put up their hand and say, we're not responsible for your claim because the policy was not in place at the time the claim was lodged. So it's for that reason that this extended reporting period is included into the policy. And the Genoa policy has agreed to honor all extended reporting periods that practitioners with the previous insurance company had. And that can go up to a maximum of 6 years, as Richard indicated earlier. In the event that a practitioner finds or feels that he or she requires longer than 6 years to notify the insurer of potential claims, then we have what's called an AERP, or an additional extended reporting period, for which the practitioner can approach Genoa and purchase at a very nominal premium, year 7 or year 8 or year 9 or 10 or 11, or as many as you would like, in fact. So that is why that period is so important. It's because it allows you peace of mind after retirement, death, physical disability, ceasing to practice, immigration, to know that you are still able to lodge claims against that insurance policy, despite the fact that you are no longer paying premium for that insurance policy. And we include that at no additional charge into the policy.
Michael John, can someone lose their extended reporting period?
So we have seen that that has been threatened in the market historically with another player. The only time that I'm aware of a practitioner losing their ERP is if they commit fraud under the policy. Okay, so if there's a fraudulent claim that is put through where the practitioner is fraudulent, the insurer has the ability to cancel that policy because of that fraud, obviously proven in a court of law. And in that instance, the ERP would fall away. The example that I'm referring to where the previous insurance company refused to honor that extended reporting period is something that's foreign to me. And it's for that exact reason that Genoa has come on, because they have declined to honor that extended reporting period. Genoa approached our reinsurers, and to show the commitment to the industry, we have matched that extended reporting period despite not receiving the premium historically for that period.
Right. Brad, there's one for you. What is the difference, and is there a difference between medical malpractice and professional indemnity?
Yeah, what a great question, hey. So thanks, Anseret. Professional indemnity is the insurance that we take against the fact that we may make an error that we're held accountable for. And basically what we do when we take professional indemnity insurance, we're saying, should an event occur where payment needs to be made because of our action, we pay a premium and we give that risk to the insurer to pay on our behalf. Back when I first started, and I want to use this as the example because I think that there's many of us who relate to this. Back in the early mid-90s, we didn't talk about professional indemnity largely in medical care. Private practices didn't have it, and state practices were covered, and we didn't think about it. So a lot of what happened with the road accident fund, and a lot of what happened with personal injury lawyers is suddenly there was a sport, firstly in the US, and then it moved to Europe, and then it moved to Australia, and then it moved here, about suing medical practitioners and healthcare practitioners for their work done. Now, the way that they made that popularized and the motion that they created for attorneys to get people to call them is they called it medical malpractice. And it's often 99 out of 100 times it's not malpractice. It's a complication that's manifested or an adverse outcome that was known or poor communication or a misunderstanding. So basically what's happened is our market in healthcare has been called medical malpractice insurance, but it's really professional indemnity insurance for healthcare. And the phrase medical malpractice is the scare phrase to get us to enroll and pay higher premiums than we need to, or evocative to get a person who feels that they've been hurt to call the personal injury lawyer.
Good, thank you. I think that answers Anzeret's question. I hope so. Anzeret, maybe you can give us a thumbs up there.
I see, if I can jump in, Lani, to the question people are asking. I see Gerard's asked about the comparison which was offered by R2/Hollars/PSY/SSA, and then I see Leslie Mayers asked something similar. So we did share a comparison document comparing the CFP R2 offering compared to the Shackleton Genoa offering. We can share that. I think Profnet may have that document. Lani can confirm. Alternatively, I can try and do you. Okay, yeah, you can ask Profnet for that, which basically shows the differences. It shows where the policies are similar. It shows where the policies differ. They are similar in some ways, and then they're different in some ways. There's quite a few additional bells and whistles under the Genoa policy because it was a more recently developed policy, such as the ability to pay monthly, which the CFP offering didn't have, and various extensions that were not included under the R2 offering as well. So that's just a summary, but there is a 1 or 2 pager explaining those concepts. I don't know, MJ, if you have anything to add there.
Yeah, for sure. So as Richard says, the policy includes some very nice extensions like a premium holiday in the event of pregnancy or temporary physical disability or the inability to work. That runs for, I think, a 3-month period. We've got a forensic audit cover that is included at a nominal premium, monthly premium that's covered in there. There are our policy for those practitioners that operate in state. In the event that you are vicariously, traditionally you are vicariously liable for your work done in state. However, if the state chooses to not indemnify you for some reason, our policy includes an extension where our defense costs will come to your aid to ensure that we defend you against a state matter where the state is refusing to indemnify you for work done in state. There are multiple extensions in the policy like that, and we would invite you to please go and have a look at that comparison document, where it's very simply laid out by Shackleton in a tabulated format.
For sure. If you're interested in
my real hand up, Lonnie.
Go for it.
Seeing these questions, and Leslie, I just wanted to answer this a little bit because we don't always realize this about our brokers. In short-term insurance, and these kind of insurance products that we're talking about here are short-term insurance, your broker every year is obligated to look into the market at the cover you've got compared to other cover available and give you a comparison and a best recommendation against your needs. That's normal broker practice. And so in this instance, what you've got is you've got comparisons that you can look that were compiled by a broker and other brokers. In terms of this journey, various different brokers were asked to give comparisons in the market. They were asked to show what product one versus product two and insurer one versus insurer two could do, and what their national and local capacity could be to manage claims. Now that's normal broker activity. Those are things that you should be speaking to your broker every year about, whether it's your car, your house, your medical aid, or your indemnity insurance. And that's where this journey was a long journey. It wasn't a 2 or 3 day journey, because some of the questions have been, well, this happened quite fast and how did it happen? And so the questions that you've got about what can we look at are well-documented comparisons that are published on the websites.
For sure. I think, Richard, you asked for Leslie to just elaborate a little bit more on clawbacks. Perhaps I can just translate, but there, I think what she's referring to is forensic audits. There's usually a clawback involved with a forensic audit. And together with that is as well, does Genoa cover billing complaints versus forensic audits? Because I think that's two different things.
Yeah, I'll leave MJ to answer that one. He's quite a specialist in that regard.
For sure. So the short answer is that yes, our policy responds up to the limit of indemnity for complaints around billing complaints. However, we do not pay for the collection agency to sue the patient, or where the patient, for example, has not paid the practitioner's bills. So we will defend you around billing complaints. That the policy defense costs will respond in that regard. Similarly, disputes regarding professional fees which have not been sent to the HPCSA or AHPCSA are not covered. Then, as Lani mentioned, there's an additional add-on to the policy, which is our forensic audit cover. Excuse me. Which for a nominal premium, Genoa offers 10,000 Rand cover, which will allow you to challenge an audit by a third party and or a medical scheme. And in these instances, the insurer appoints an expert to assess and report on the items that are to be audited. So in those instances, we are in your corner and we're batting away for you to assist you. We know how scary it can be when these big medical aid companies come at you, and that's why we would like, or that's why we've developed this cover, particularly in a response to, we've listened to the community and we've developed the cover and now offer it.
Fantastic.
I'd like to make a comment on that, because I see Leslie's response. You need to understand that if you have been billing inappropriately and you've got to pay back 250,000 Rand because your ICDs or your procedure codes were wrong, well, that's your liability. That's not a liability that you can insure against. Inappropriate billing, inaccurate billing, double billing, use of the wrong modifiers or procedure codes are one issue. If your billing is correct and you can show your billing is correct, then the ability for us or for these guys at Genoa and the team to support you, that's an entirely different journey, because then the money is more than enough to cover your defense costs, because that's how that journey works. So just to give you the perspective, the clawing back for something that you've done incorrectly is completely different for defending you from a frivolous, vexatious, or hostile claim made by a third-party payer.
Good, thank you. Thanks, Brad. I'm just glancing over to the Q&A section as well, and there's an anonymous attendee with a question. Are psychologists covered for a claim made by a client that is in South Africa, but living in another country? So in other words, the psychotherapy is happening online. And I think the telemedicine aspect here plays a role as well. Does Genoa cover telemedicine?
Yes, so Genoa do cover telemedicine, absolutely. We cover you up to 10% of the limit of indemnity selected. Telemedicine is a regulated space in South Africa. Brad is more the expert on that space, but the short answer is that yes, we do indemnify for telemedicine. And as I said, that's up to the 10% of the limit of indemnity that the practitioner has elected. Brad, I don't know if you want to speak more to telemedicine around that particular issue. I know you are an expert in that field.
Yeah, thanks, MJ. There is a difference between telemedicine and telehealth, and we have to decide a couple of things. We're talking here about telehealth because telemedicine suggests that you are with the patient and you're calling another patient, or there's a healthcare practitioner with that patient who's calling you. That's telemedicine under our definitions in South African context. Telehealth, which came out since the COVID pandemic, is an extension of that, saying during the time of this pandemic, you can have a direct consultation with another person. If you're consulting with people outside of the territory, you have to bear in mind that there are some risks. The first risk is that they are aggrieved with you and they take action against you in your country of registration, which is here. The risk in terms of medical tourism, because to some extent, by consulting to people in other countries who are not South African domiciled or South African citizens, is you're now entering into the space of medical tourism. Now the question would be on their side, if they're aggrieved with what you've done, and they take action in their country against you, you would then have to go and defend that, because you'll have to defend why you're providing extraterritorial or outside your territory of registration care. So I think this is much bigger than that. The issue here is if you're doing telemedicine and the action, or telehealth, and the action against you happens in country, you have defense through this product. And I'm going to go back to you for how your policy sounds. But you do need to be very that if you're providing global consultation, that you run the risk that the action taken by the aggrieved person is done in their country, under their laws, with their levels of fine. And that's an entirely different script, and it's an entirely different structure.
Good. Guys, I want to use an example, and I'm going to use myself as an example. Let's say it's 2021, today, the 4th of February. Let's say I was still in private practice as a speech therapist. My mother will be very pleased because she used to be a speech therapist. I've got my malpractice insurance with you. And I realize now that something happened back in November 2020 of last year. There might be a claim against me. Who do I notify? Do I notify my previous insurer, or do I notify Genoa?
Lani, that is you're hitting us with some very good questions, but that one in particular is incredibly pertinent and a great one for your members to understand. So again, I'm going to go back to the definition of claims-made based insurance policy and that retroactive date that Richard mentioned. So in your example, the date that you first started practicing would be the retroactive date that's taken out. Let's assume that that's 1 January 2019. And on 1 January 2020, you moved across to Genoa. Now it's, what day is it today? Today is the 4th of February, and you suddenly become aware of a potential claim against you for work done in October or November of 2020, for example. Genoa would be the insurance company that is responsible for that claim. And the reason for it is because we've matched your retroactive date, and we are now the insurance company that is on risk for the historical work that you did. Okay, so despite not receiving the premium for that historical period, because it's a claims-made based policy, we honor those potential claims that that have not yet been reported, and which are only reported in the new insurance period, being 1 January 2021 and onwards.
So in this case, yes, in this case, I'm just going to recap that and make sure that I'm understanding it correctly.
Sure.
It's the 4th of February 2021 today. I'm
Yes.
being made aware of something that might have happened back in November last year. I need to
Yes.
inform Genoa.
You would inform Genoa, and Genoa would respond to that claim on your behalf. The only disclaimer around that point is, had the practitioner been aware of the claim and reported it at that time to the previous insurance company, then the previous insurance company would be responsible. But in the event that the practitioner is not aware of that claim, and they only first become aware of it, for example, today on the 4th of February, then Genoa is responsible for that claim.
And if I didn't have insurance last year?
If you didn't have insurance last year, then your retroactive date, which is the important date Richard mentioned, would only be the 1st of January 2021. So therefore, any work done prior to the 1st of January 2021, we are not responsible for, because you were never insured at that time, and therefore you can't expect to be indemnified by an insurance company for a period where you never had insurance historically.
Okay, so that would be for my own, yeah, okay.
Absolutely. It would be, if you liken it again to a car example, it would be like crashing your car and then taking out an insurance policy and then expecting to claim for that accident.
Get
It's
it
the
paid.
same kind of concept.
All right. So something happens. What's the process? Who do I contact? When do I contact? Is it the sooner the better? What should people do? What advice can you give them?
Rich, I'll take this one. You can take the next few. So guys, my advice is always that if you're concerned about something, then reach out to us. That's why we're here, and that is why we employ experts in the different fields to assist you with the stress and trauma associated with the claim. So you've got multiple ways of reaching out to us. If you have a medical malpractice or a medical claim, or you simply want to bounce something off our attorneys around something that you're concerned about, you can phone the Genoa helpline, which is, and Lani, perhaps you could just pop that up into the chat notes, but I'll mention it here, 010-286-1915. On that line, you're going to get multiple different options. The first is to speak to an underwriter. The second is to speak to a manager. The third is to speak to a qualified attorney. And the fourth is to speak to a medico-legal advisor. Depending on those options that you get, you would obviously be routed through to the relevant people who will be able to assist you with any queries. In the event that you're a person who doesn't really like speaking to anyone, we also have the option for you to notify us of potential concerns via our email address, which is claims@genoa.co.za. And in that instance, you'll have direct access through to my company, Genoa Underwriting Managers. Alternatively, if you have a broker query, that's where Richard's company comes in, and you can notify them on medmal@srisk.co.za, or alternatively on their landline, which is 011-784-5373, I think, Rich, is that correct?
Going too quick for me. 011
784
784
5373.
73.
I think that's their number. Richard, you'll need to confirm. 784-5373. Yeah,
That
I'm
is
correct.
MJ. Well done.
Thanks, guys. Trying to keep up with you.
Perfect. So Lani, yeah, like the practitioners must never feel like they're left in the cold. We are always just a phone call away or an email away, and we'll do whatever we can to assist with putting that practitioner at ease.
And did I hear correctly that if there is a claim against me, that you do have lawyers on standby that can actually assist?
Absolutely. I would actually urge the members to try the helpline after this call. Elect to speak to the correct option, which is speak to an attorney, and test it. But yes, we've got an in-house attorney who's available 24/7 to deal with medical malpractice claims that may arise for the practitioners that we currently insure.
Okay. Guys, so 2 questions from me. Is it too late to join? Can people still join? Because it's the 4th of February.
Yes, I can answer. So you can definitely. From what I understand, the payment portal's open and you can join. You know, just for context, you can cancel any South African insurance company with policy with 30 days notice. So that's the law, you know, so you can switch any insurance policy, short-term insurance policy that you have with 30 days notice. So you can always switch.
Good. If anyone wants assistance with that or just some wording advice, you can contact us, info@profnet, and we can definitely assist you with that. We've got the information available. So that's good news. So it doesn't matter that it's the 4th of February, people can still join. I presume you need to still pay for your premiums then for January and February, is that correct?
Yes, correct. So it would all be dependent on when the practitioner wants to elect their cancellation. If they want it to be from inception of the policy, which is 1 January 2021, they would request that refund from the existing insurer. The insurer should refund that. We would say if they're dragging their heels more than 2 weeks, but within 2 weeks, you should receive that refund. And then you would obviously pay the historical premium to be insured from 1 January 2021 with Genoa. Alternatively, in the event that you want to, if you want to incept from, let's say, the 1st of January, we can also do that, subject to you showing us that you've had unbroken cover with a previous insurance company, and you could elect to go forward with us from there.
Excellent. Thank you. Brad, a quick one for you, and then perhaps MJ need to come in as well. Informed consent with a patient. As a healthcare provider, that is obviously super important. Would you agree?
Absolutely. No, it's not only a requirement, it's a legal requirement. So if we go back and we say, how does life work in our profession? First, we have the Constitution that tells us that everyone has the rights to healthcare and everyone has the rights to bodily integrity and everyone has the rights to access to care under sections 12 and 27. If you can't sleep, you go read them. But then off the back of that is the National Health Act. And then off the back of that is the Health Professions or the Allied Health Professions Act. That's what gives us permission to register and gives the Health Professions Council or Allied Health Professions Council its mandates. Now, the Health Professions Act is very clear that it says you have to do informed consent. And it describes how you need to do informed consent and that it has to be understandable, mutual, intelligible, given by somebody with the capacity to do so. And we can spend hours on that. But informed consent is really important. Equally, there's this thing that we often forget about called the patient charter. And those of you that are registered with the Health Professions Council, it's booklet 3 of the ethical guidelines that says there are rights that the patient has in and amongst everything else to know who their practitioner is, to have rights to access to care, to have continuity of care. But it's also got the obligations of the patient to fully disclose, to participate in their care, to follow through on recommendations in a reasonable way. So all of that relates to this balance of consent. So Lani, absolutely. If you are practicing without formal consent, not only are you behaving in an ethical and social way incorrectly, but you're not consistent with the legislation that gives you permission to act.
And does the same go with Genoa? Is that a requirement, Michael John?
Yes, Lani. So naturally, as you're speaking, I'm just trying to respond to some of the queries here that are coming up on the chat function. But yes, so it is a condition precedent to liability that a member is required to provide evidence to the satisfaction of the insurer that they have in fact obtained informed consent. Genoa, as the members will be able to see, has provided a comprehensive informed consent form, which is actually on the Profnet members portal, and we would urge you to please go and have a look at that and to try and incorporate it into your practices wherever possible.
Good, thank you. Are you...
sorry to interrupt you. May I just address Elizabeth's question, which is, it's an important one because I don't want there to be any misunderstanding with that.
Please do.
Elizabeth, you've asked whether if you have not had insurance with any insurance company last year and you've done work for the year 2020 and then you move across to Genoa on the 1st of January 2021. And then let's say today you have a claim for some work done in 2020. You've asked whether we would cover you for the work done in 2020. The answer is no, we would not. And the reason for it is because you have not had an insurance policy in place historically. It's like the example that I said to you where you crash your vehicle and you're not insured, and then you take out an insurance policy and say, hi, I've had an accident. Will you please cover me for the claim?
No, thanks for clarifying that just again. I think that is a very, very important one. So guys, let's take it a step or two further. So I come to you as a healthcare practitioner. I informed Genoa that there might be a claim against me. What's the next steps? What happens down the line?
Before you guys answer, can I just step in, Lonnie?
Please.
Because I think that there's a few steps here as a practitioner that we need to know. The first thing is, what constitutes a need to notify or inform?
Fantastic. Yes, please.
Because we're talking about, well, we need to notify, or there's a circumstance, or there's a claim. But the first issue is when we're in the rooms with the patient and we have a reason to believe that there was a complication or an outcome that was unexpected or adverse, or the patient is aggrieved, even though we did a great job. They might not like your billing schedule. They might not like the proximity that you stand in. They may feel that you were sexually inappropriate. They may not feel you were sexually inappropriate, but whatever the case is, any time that you think, gosh, I should make a note in my record that didn't go as well as it might have, is where you then notify your broker, who notifies your insurer that you have something you're worried about. You can call that a circumstance or a notification, but you need to then, at the time that you would make a note in the record that says, so-and-so expressed dismay, dissatisfaction, unhappiness, or in the follow-up, they said that they weren't coming back because they were unhappy. If you're making a note in your record that Brad was unhappy when you saw him, for whatever the reason was, breathless, moody, tearful, repudiating the money, or your receptionist phones and they say, no, I'm not paying you. You hurt me and I went somewhere else. And so I think you guys are rubbish. Whether it's bona fide or not, it's immaterial. You make a note in your file and you notify the broker that you've had something that they should be aware of. Whether or not it materializes is incidental. Then if you get a letter of demand or a summons or a letter from an attorney, you notify the broker. So my experience, and I limit my experience only to 20 years of this, is you're always going to have two conversations. The first one when you're worried to let them know, and the second one when action's been taken against you. Because the attorney, the personal injury attorney of your patient, they're not going to write to Richard or Michael or somebody else. They're going to write to you. You're going to get a summons, or you're going to letter that says, Dear Dr. Brad, I'm writing to you with respect to your patient, Lonnie Ace, who has expressed her extreme dismay and retained me, blah, 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 blah. You send that letter to you either phone, because it's like a panic when it comes, and you phone the direct line that you've got, or you call your broker and you say, hey, I've got this, let's put this on record. So that's how you know when you need to record something and notify.
I think it's a very important thing to know. Thank you. Thanks for addressing that, Brad. Definitely. So you thought as a healthcare provider, something might have gone wrong. You pick up the phone or you email your broker. Richard, what do you do next?
So from our side, it's important to differentiate in terms of responsibilities. We don't give advice on your claim. That's not our position. We will direct you to the claims handler at Genoa immediately, and they'll get back to you. I can't guarantee within the hour, but certainly within the day.
Yeah, so if I could speak more to that, we would either receive the notification via Shackleton, alternatively on the claims at Genoa email that I've indicated to you. That will be fielded by one of the team in-house, and the response time, at least acknowledging that we've received it, and very likely a phone call, is within 24 hours. it's often same day, but we set ourselves what we believe to be a more realistic term, or timeline, which is 24 hours. Again, if you can't wait that long, the 010 number that I mentioned to you, you can always circumvent the 24-hour email response time and go directly to source by speaking to a medical legal advisor or alternatively attorneys.
Excellent. Gents, we're slowly running out of time. So perhaps you can just sort of gather your thoughts a little bit about some closing remarks there. What I do just want to do in the meantime, most of the questions that we discussed today is in a frequently asked questions document. I'm going to try and paste it here in the chat functionality. I'm not sure it will be possible. Otherwise, if you do require the document, because it's not working at the moment, it's a PDF document and I can't seem to paste it. Again, please just contact us at Profnet and we can give that document and send that document to you. I'm not sure, Michael John, if you can try and do the same, but I don't think I have the ability to paste a PDF document in the chat functionality.
It's not allowing me to, but
No.
But yeah, again, if we could just direct the members back to the Profnet portal.
Anytime.
There's a wealth of information that Genoa has put together to educate the members. There are practice management tips. There are explanatory documents about complex things like what is prescription. It literally is an encyclopedia of information. So please, can you go there and have a look if anyone's got any questions? Alternatively, as I said, we're all just a phone call away. Pick up the phone, get hold of us, and we're here to assist you. Clients are not just policy numbers in our views. You're individuals with individual needs, and that's why we make ourselves readily available and accessible to the members.
Brilliant. Thank you. Thank you, Michael. I literally just circulated those two email addresses again, one for broker and insurer advice. And if you need anything from Profnet Medical, please just email us on info@profnetmedical.co.za. We've got 3 minutes left. I just want to tell everyone what is happening next week. Brad, I do believe we've got you again. It's got a bit of a different twist to it because we're meeting on Tuesday, the 9th of February, between 6 and 7, if I'm not mistaken. This is again a webinar sponsored by Genoa and Shackleton for a conversation on risk management aspects while dry needling. Brad, why should, and I think this is mainly for physios and chiropractors, why should they be joining us? Who else is talking with us? Maybe you can give us just one sentence, a recap of what we're going to be talking about next week.
Yeah, Lonnie, thanks. And it goes to your question of informed consent. We're talking about the risks related to dry needling and what you need to tell people, your patients and their family, what they could expect and how you should respond in the event that you do dry needling. And it's myself and a physiotherapist, Bruce, and both of us have had deep experience in this from our respective practices and also from defending people who've gone through these journeys before. So that's what we're going to be talking about. And really what we're talking about, and Lonnie, next week is on dry needling, but the principle is you don't keep records so that you can meet the insurer's requirements. You're keeping records because that's what your registration says that you should do. That's your patient obligation and your diligence. So that's what we're going to talk about next week, and that's a lot of what we've spoken about today.
Excellent. If any of the physios, chiropractors are interested in joining, I literally just posted the link to that Zoom invitation. You can just register on that platform, and we look forward to seeing you next week, Tuesday then. It is slightly later, between 6 and 7, just to try and accommodate the majority of the clinicians. But guys, let's quickly go around the room. We've got about 1 or 2 minutes left. Michael John, let's start with you. Richard, your lasting thought, and then we'll leave the closing for Brad.
Yeah, I think my last, my last thoughts would just be just in light of talking to, I think it's Solomon, any adverse incident you come across in your career, just tell us. It's always in your best interest to just be transparent. You don't need to hide from incidents. Just be transparent. It's always in your best interest. Go for it, MJ.
Thanks. I'd just like to reassure the practitioners of one of the major focus points of Genoa as an insurance company, and that is about making sure that you, the practitioners, are as educated as possible around potential pitfalls and things that exist in the medical malpractice space. I know that in insurance, they're large words, and I use this joke frequently so the panel won't laugh, but like Tyrannosaurus Rex, that sound very complex, and it's our job to explain those to you simply and to make sure that you are comfortable with everything, make ourselves easily available to you, and to take the stress and concern and trauma away from any events that may come across your practice. So you'll see that, like the dry needling event that we're going to be doing, there will be a number of these CPD events that are going to be held in the coming months. And that, from our perspective, is again a way to give back to practitioners and ensure that the group of practitioners that we do insure are of a preferred risk and the highest possible caliber of insured that we can potentially seek out. All right, so yeah, I hope that makes sense, and thanks to everyone for your time.
Thank you. Thanks, MJ. Brad, a last word from you, please.
Sure. Look, I think when I reflect on this conversation and why I got involved with this is treating patients is two things. It's a delight and it's a significant responsibility. And I'm nervous still every day when I see patients. And the purpose of these kind of dialogues and this kind of support is to embrace us and make our practices stronger in the areas that we don't focus on every day. We focus on patient care, we focus on intimacy, we focus on good outcomes. And these kind of experiences, with the experience of Michael, John, and Richard, and Lonnie, and everything else around you, is to make practice a safer experience. And as long as we remember that this is what these are about, we're always going to have pitfalls and risks because we're dealing with people, and people are complex, including ourselves. And so it's a privilege to be here with you, and thank you very much.
Excellent. Gentlemen, thank you for your time. Attendees, thank you for joining us again. It was lovely having everyone with us again after about 2 months of a break. It's time to say goodbye. Apologies, we ran over with 2 minutes, but do have a safe and very pleasant week ahead, and keep an eye out for some of our future webinars. Until then, please take care of yourself. Bye.
Thanks, everyone. Enjoy the rest of your evening. Bye.
Goodbye now. Thanks, Lonnie.